Good morning, everyone. Welcome all of you joining the public presentation organized by the Occupational Health Center. Today, the topic is about workplace sexual harassment, the legal resources in Manitoba. We are so pleased to have Carlyn, the workplace sexual harassment lawyer, and Victoria Weir, the sexual harassment program coordinator from the Community Legal Education Association, CLEA, to come in to present for us. We would like to begin by acknowledging that we are on Treaty 1 territories, the traditional territories of the Anishinaabe, Greek, OG Greek, Dakotas, Indigenous people, and the homelands of Native Nation. We respect the treaties that we were made on these territories, and we acknowledge that we are all treaty people. At the Occupational Health Center, we commit ourselves to a process of reconciliation with Indigenous community. For the audience participation and follow-up, please put your question on the chat box section on the right side of your screen. We will try to answer the question after the presentation. We may not be able to cover all the questions in the Q&A. Please also connect with us after work, to follow up. The event is also being recorded for review later. So, and you could even share with your content, share with your contacts or any network if you want to. And also the session will be shared on the social media. And please also participate to the follow-up evaluation survey, giving us some feedback, for follow-up to making sure how we could do the improvement for the upcoming event. For the Occupational Health Center, some may know that we are community health center funded by the Winnipeg Regional Health Authorities. We are currently located on 167 Sherbrooke Street, Winnipeg, Manitoba. We provided the services to the Manitoba workers with work-related health issues and work closely in the Joint Workplace Health and Safety Committees for trainings. And please also visit our website for information and the resources. So I will put the link for the website on the chat later too. So this is the time. Please join me to welcome Victoria and Carlyn.
Perfect, thank you so much. I'm just going to share my screen and we'll make sure that everyone can see. Okay, hopefully everyone can see this. Okay, perfect. Okay, wonderful, thank you. My name is Victoria and this is my colleague Carlyn. So we work with the Community Legal Education Association. Thank you so much for your interest today in our topic, which is workplace sexual harassment, legal resources in Manitoba. We are hoping to keep our presentation to around 40 to 45 minutes of content with the following Q&A, but we'll see how that goes. We also wish to acknowledge that we are located on Treaty 1 territory as an organization on the traditional lands of the Anishinaabe, Cree, OG Cree, Dakota, and Dene peoples, and on the homeland of the Métis Nation. So while we work primarily in Treaty 1 territory, and that's where our office is located, and it's where I work from home, it's also, we also work with and serve communities located in the territories of Treaties 2, 3, 4, and 5. So all across what we now know is called the province of Manitoba. And when we talk about the legal system today, we're talking about the legal system that we operate within. We're talking about a legal system that we acknowledge is not traditional to these lands. We also want to let you know this workshop does talk about some sensitive content. So we will be talking about, of course, harassment and discrimination in the workplace. And we will be talking about some case examples. So that can bring up some difficult feelings, and we do want to acknowledge that. So please feel free to step away from your screen. It's a webinar, so your camera is not on. So please feel free to do whatever you need to feel supported. Talk to someone that you trust for support, anything that works for you. Also, we just want to let you know that we won't be asking anybody to talk about examples from their own life, and that's for everyone's privacy, but also just so you know that we won't be asking that of you or of anyone attending the workshops. And our final disclaimer, because we are lawyers, is just to let you know that this presentation is intended as legal information, not individual legal advice. So we will talk about what the law says, what your options are, things like that, but it's not necessarily the best time for individual advice, both for the sake of time as well as for your own privacy. So we will have some resources at the end of the presentation today where you can get some help and resources for individual situations. This is also just an introduction, so we wish we could talk about this for a lot longer, but we are keeping it to a 40 to 45-minute presentation for everyone's morning today. So if you have other questions, we'd be happy to try to answer those or to connect you to other resources. As we start today, we'd also like to introduce our organization. So just to let you know a little bit more about what we do. So the Community Legal Education Association is a nonprofit organization in Winnipeg that's been operating since 1987. So it began with kind of some legal information hotline resources, but our programming has really expanded to include a lot more projects since then. Now we have workshops, publications, we have a community intermediary legal training program, which has another session coming up soon, actually. We have an annual conference that's now delivered by webinar, and free online materials and videos as well. Our workplace sexual harassment project specifically launched on January 21st, 2020, and that has two components. So we have the community outreach component, which is where I work. And since January 2021, we've provided 30 different presentations to 11 organizations, reaching around 20 communities in Manitoba. And then we have the sexual harassment hotline, which is kind of the main part of the project, and that's where Carlyn works. And since January 2020, that part of the program has assisted over 175 clients with over 350 calls. So we still have funding for a few more years for this project, but we're pleased with how it's going so far. So today we're hoping to start talking about important laws for workers, how to know which law applies to your situation. We're going to talk about definitions of harassment and discrimination under the law, which may be different in some cases than kind of the common understanding of those words. We're going to talk about rights at work and specifically employers' obligations towards employees. We're going to talk about some case examples and legal resources, and then we'll have time for question and answer if that works for everyone. So we'll start by talking about important laws for workers, and understanding kind of the basics of these laws is important to understanding our rights in the workplace. So the first step is determining which law actually applies to you. And that's really important to know because you might hear people talking about a law in another area or another jurisdiction, but laws about employment, human rights, harassment can be really different depending on where you live and what kind of work that you do. So it's important to know which law applies to you so you know where to go for help and what your actual rights under the law are. So the laws that are going to apply to you are going to depend on two main factors. The first is what we call the jurisdiction. So whether the federal or provincial government gets to make the laws about that kind of workplace, and whether or not you have a union. So a little bit more about jurisdiction, that comes from Canada's Constitution. The Constitution sets out whether it's the federal government or the provincial government that gets to make laws about certain matters. So some workplaces in Canada fall under federal jurisdiction. So some of those would include banks, the postal service, interprovincial pipelines, shipping by rail or trucks between provinces, airlines, things like that. There are some others as well. So those all fall under federal Canada-wide laws relating to employment and human rights, and we'll talk about those. All other workplaces in Manitoba fall under Manitoba's provincial jurisdiction. So Manitoba's own laws apply, and that covers around 90% of workers in Manitoba. So we'll talk about those as well. Also, if you are part of a union, you'll have, of course, a collective agreement that sets out those agreed rights and responsibilities beyond the minimums set out in law typically. So that's another factor to consider on which law applies to you. We'll start by talking about the Canadian federal laws. So there are several federal laws that regulate workplaces, but we're going to focus on two today. the Canada Labour Code, and the Canadian Human Rights Act. The Canada Labour Code sets out minimum standards for things like workplace health and safety, industrial relations, standard hours, wages, vacations, holidays, and that's for federally regulated industries. So it combines some of the elements that we'll see in comparable Manitoba legislation that is split up into a couple acts, and complaints about the Canada Labour Code can be made to the Manitoba Regional Office of the Labour Program. So we're just going to talk briefly about these laws so that you know, as we talk about them later in the presentation, kind of the basics about them. The Canadian Human Rights Act, again, it's a federal law and it prohibits discrimination in federally regulated industries. In doing that, it establishes some basic equality rights at the federal level. Complaints about violations of the Canadian Human Rights Act can be made to the Canadian Human Rights Commission, and then they would go to the tribunal. So turning now to Manitoba's own laws. There are many Manitoba laws that regulate workplaces, too many for us to go into today, but we're going to talk about three main ones, mostly two. They're the Employment Standards Code, the Workplace Safety and Health Act, and the Manitoba Human Rights Code. The Employment Standards Code, again, it's a provincial law just for Manitoba that sets out minimum standards for things like wages, working hours, and statutory holidays, sick leave, things like that. Complaints about violations of the Employment Standards Code can be directed to the Office of Employment Standards. So the name of the office has the same name as the act, which is helpful. We will be talking mostly about other legislation today, mostly about the two laws that are going to follow, but sometimes employment-related issues do come up in the context of harassment or discrimination. So that's why we do want to mention this here, that unlike the federal legislation, which combines those aspects, if you're having an issue with these areas in Manitoba, this is the office that you would speak to. The Workplace Safety and Health Act, again, it's a Manitoba law, and this one is meant to protect workers' physical and emotional safety in the workplace. It has several regulations for specific workplaces, especially for those with a higher risk of physical harm associated with them, but it also includes regulations about harassment that are really important here in Manitoba. And those are relatively new and have been updated somewhat recently as well. Complaints about violations of the Workplace Safety and Health Act can be made through the Office of Workplace Safety and Health. And finally, the Manitoba Human Rights Code. Again, as the name suggests, it's a provincial law, and it protects Manitobans from discrimination and harassment. It applies to multiple contexts, so not just the employment context, but that's, of course, the context we'll be talking about today. And it also, like that's the same for its federal counterpart as well for the Canadian Human Rights Act. It applies to both paid work and volunteer work as well. So that's just something to keep in mind, that volunteers are also protected under the Manitoba Human Rights Code. And complaints about human rights violations can be made to the Manitoba Human Rights Commission. So as we've talked about these written laws as a source of law, maybe the biggest one when we talk about employment and human rights, we also want to acknowledge case law, which we will be talking about later in the presentation. It's another important source of the law and how we understand the law in Canada. So individual cases that are heard in courts and tribunals also form part of our understanding of the law and also the law itself under our common law system. So judges and adjudicators interpret written legislation in their decisions. And in many situations that lets us rely on those past cases and decisions as what we call precedent. So it's the legal principle that says that it's most fair for similar cases to be decided in similar ways across time. So we can rely on past cases to argue for how future cases should be determined. So cases are generally published. They are available for free online on an online database, generally speaking, as well as summaries are generally available as well to make them available to the public. So we will be talking about some cases later on that help us understand some of these principles and kind of flesh out what's written in the law, but just to keep this in mind for now. So with that, I will turn it over to Carlyn to talk a little bit more about harassment and discrimination.
Thank you, Victoria. Sorry, you'll have to forgive me. I've got a little bit of the tail end of a cold. So I guess going over to the next slide. So, okay, just going over some statistics for sexual harassment generally. According to a 2017 survey, 60% of employees have experienced harassment at work at some time. Specifically, 30% have experienced sexual harassment. Going over to the next. Also, if you break it down, 90% of women have had to report changing their behavior at work to avoid sexual harassment or discrimination. And we'll get into a little bit about what that looks like. More specifically, 47% of LGBTQ+ workers report harassment and or violence at work, and 80 to 90% of transgender or non-binary individuals also report harassment or violence or sexual harassment at work. Move over. So the key takeaway and the protections that are supposed to be guaranteed to workers in the legislation and the subsequent case law is that everybody has the right to work in an environment that is free from sexual harassment, general harassment, discrimination, or violence. So discrimination is a basis of a protected characteristic that is against the law. So this includes discrimination in the workplace, and we will get into certain grounds of discrimination as well. So as Victoria had mentioned, there are certain federal legislation that protects workers and protects against discrimination, as well as provincial. So looking at federal legislation, one of those laws is the Canadian Human Rights Act. So this protects workers who are federally regulated, like some telecommunications, transportation, for example, on reserve Indigenous employers. So the protected grounds of discrimination as per Section 3, subsection 1 of the Act include race, national or ethnic origin, persons of color, religion, age, sex, sexual orientation, gender identity or expression, marital status, family status, genetic characteristics, disability, as well as conviction for an offense to which a pardon has been granted. So if you were convicted or pled guilty to an offense that was later pardoned, that also is a ground of discrimination. So it is a discriminatory practice directly or indirectly to refuse to employ an individual based on one of those grounds of discrimination, or to employ them, but then in the course of that employment to differentiate and to use different practices in dealing with that employee on the basis of one of the protected grounds of discrimination as well. And then there's also the provincial codes. So on top of the federally regulated types of employment, as Victoria had mentioned, 90% of employers in Manitoba are regulated by provincial legislation. So if you're not regulated by the federal regulation, you're mostly covered by the provincial. So again, it's very, very similar grounds that are protected against discrimination. So we have ancestry or race, nationality or national origin, ethnic background, religion, age, gender identity, sexual orientation, marital or family status, source of income, political belief or political association or activity, physical or mental disability, and social disadvantage. So discrimination generally means treating somebody differently because of their membership in a group. So it's again, employing them, but treating them differently based upon a ground of discrimination. treating somebody differently on the basis of a protected characteristic, treating someone differently based on their association with somebody who has a protected characteristic, and failing to reasonably accommodate the special needs of somebody in a protected characteristic. Now, it is important to note that there is a duty to accommodate to the point of undue hardship for an employer, specifically in terms of an employment situation. The code does broadly also apply to things like tenancies and accommodating people stay in a place of business as well. Okay, so going into harassment. Next slide. So harassment generally was defined in a Supreme Court decision in 1989, which was the Jansen case. So really, this is what laid out the test for sexual harassment that has later been codified in a lot of these pieces of legislation that were brought into law after this court case was decided. So in the judgment, Chief Justice Dixon said that sexual harassment in the workplace may be broadly defined as unwelcome conduct of a sexual nature that detrimentally affects the work environment or leads to adverse job-related consequences for the victims of harassment. When sexual harassment occurs in the workplace, it is an abuse of both economic and sexual power. So that's the test. Generally, we see it reflected in the legislation. In terms of trying to determine whether or not something is sexual harassment, the legal test is a balance of probability. So this is different from other standards of proof, say in criminal law, where it's beyond a reasonable doubt. This is on a balance of probability. So it's a lower standard and it comes from an objective test. So it means that the reasonable person, your average reasonable person, if they would consider that conduct to be sexual harassment, then that would be the test. Next slide. So, excuse me, looking back at federal legislation, there are certain definitions that come from this Jansen case from 1989. So the Canada Labour Code actually defines it as any action, conduct, or comment including of a sexual nature that can reasonably be expected to cause offense, humiliation, and other physical or psychological injury or illness to an employee. So it, again, goes back to the objective test of the reasonable person. And then in the Canadian Human Rights Act, it defines harassment as a discriminatory practice in the provision of goods, services, facilities. So again, it goes to tenancies and public service. That's customarily available to the general public or in the provision of commercial premises or residential accommodation or in matters related to employment. And it is automatically deemed to be a prohibited ground of discrimination if it is sexual harassment. Okay, next. And then going towards our provincial legislation, harassment is defined as multiple acts of abusive and unwelcome behavior based on any protected characteristic and multiple offensive or unwelcome sexual advances. A single sexual advance made by a person in a position of power, such as giving a benefit or taking it away, if they knew that if they knew or reasonably should have known that it was unwelcome, or any threatened reprisal. So if somebody reports a sexual harassment and then they have a loss of opportunity for advancement, if they're fired or their hours are cut, then that can be seen as a reprisal, which is also against the law. Okay, next. And then we also have the Workplace Safety and Health Act. So this means harassment means objectionable conduct that risks a worker's health or severe conduct that affects a worker's psychological or physical well-being. Harassment is objectionable based on a protected characteristic. And it's important to note that it's not necessarily limited to one characteristic. Somebody could experience discrimination, say, on disability or sexual orientation, in addition to gender. So there is some intersectionality there. That's quite common. It's considered severe if it is repeated, humiliating, or intimidating, or in the case of a single occurrence, has lasting harmful effect. Okay. So we also have a slide here of what is not in these definitions.
I can take over, Carlyn, if you'd like. Perfect. So, and when we talk about conduct too, we just want to note that, especially in the context of working from home and things like that, questions that we get often are what kinds of locations or events can this conduct be related to? So we just want to note that under the federal and provincial legislation as well, it can include conduct when someone is working from home, whether that's through electronic communications as well. If someone's at a work conference, if someone is traveling for work or at work-sponsored events or training, those can all, those all have a direct nexus to the employment context. And so those kinds of situations can all be contexts where behavior that falls under those definitions can be grounds for a complaint as well. So when we look at these definitions, we just also want to point out what is not in them. So one thing that's not actually factored into the test is actual sexual attraction or some sort of measure of that. When we talk about workplace sexual harassment, the actual subjective sexual attraction is not necessarily relevant or necessary to prove in these cases. More important is we're looking at a power imbalance, a lack of boundaries. So that isn't actually factored into the test of that subjective sexual attraction. It doesn't need to be proven or disproven on either side. We're looking at what a reasonable person would see. And similarly, there's no one picture of a harasser or what that would look like. So harassment can happen between people kind of regardless of the gender dynamics. There's no one picture of a person who's engaging in harassing or discriminatory behavior. It's whether or not that behavior meets the test in the legislation, essentially. So we'll discuss that in some cases coming up, but it's certainly not always the picture of a man harassing a woman. We see all sorts of dynamics in the case law as well as in real life. And finally, there is no actual need for a subjective intent to cause harm. A person can have a neutral or even positive subjective intent in their own mind and still be engaging in harassment or discrimination. So we see that sometimes where one person interprets their own actions as flirting or kind of a benign interaction, but the person who's the subject of that interaction does not feel that it's flirting, they feel they're being harassed. So it's more about the observable effect on the person, not necessarily the intent of the person who's engaging in that behavior. So that's something we wanted to point out as well. And like Carlyn had mentioned, we also want to recognize the reality of intersection. So discrimination or harassment can occur certainly based on multiple protected grounds at the same time. This is reflected directly in the Canadian Human Rights Act. So Section 3.1 talks about how a discriminatory practice can include a practice that's based on one or more protected grounds of discrimination or the effect of a combination of those protected grounds. So while that's recognized directly in the Canadian Human Rights Act, it's also a principle that applies in both the federal and the provincial context, certainly. We recognize there are many people who live with multiple pieces of their identities that are protected characteristics at the same time. So if they are facing discrimination, for example, based on their race or disability status, and then also facing those unwanted sexual advances in the workplace, that can make the overall negative impact of that situation a lot more severe in terms of the impact on them. And so that's something that we recognize as well. So now turning to employers' responsibilities, we have some quick notes on employers' responsibilities kind of generally summed up. Employers are responsible essentially for making sure that that work environment is safe for workers. And to boil down what the law says, employers essentially have a duty to, for one, take reasonable steps to prevent harassment and discrimination from happening in the first place. Now, what's reasonable is going to depend on the context and the setting and what that workplace looks like, but there is an obligation to do something preventative, not just responding to an event that has occurred, but preventing it in the first place. Employers also have an obligation to investigate any complaints that they do get, and to ensure that when they get a complaint, that the behavior that's been complained of stops. Employers also have to have a harassment policy. So specifically under the Manitoba Workplace Safety and Health Act, in the regulation, it establishes that all workplaces need to have a harassment policy, and not just have one, but it also needs to be made available to staff and to workers. So ideally, it would be posted in the workplace, but workers have to be made aware of it, whether that's posting it on a common server or distributing a copy regularly when someone is onboarded. There are options, but there does have to be a policy. Employers also have to take action about any person who subjects a worker in their workplace to harassment or discrimination. And that includes not just other employees in the workplace, but also potentially, depending on the workplace, other people like customers, delivery people, third-party contractors. It can depend on a case-by-case basis, but we will talk about a case example where this became very relevant. And finally, employers have a duty to prevent reprisal. In addition to the section that we talked about earlier, it's kind of a more broad obligation to prevent reprisal or retaliatory behavior. The Manitoba Human Rights Code, the Manitoba Workplace Safety and Health Act, and the Canada Labour Code all talk about reprisal. They all say that no person is allowed to harm or threaten anyone who files a complaint under the law, who gives information about an unsafe workplace, who participates in a hearing, who exercises their rights, who refuses to break the law. So reprisal can look like a lot of different things. It can look like canceling shifts. It can look like firing someone. It can look like cutting their wages or their duties, or engaging in further harassment in the workplace. Basically, that punitive behavior. All of that is an obligation on employers to prevent that from happening, whether that is coming from the employer directly or from someone who is acting either on behalf of the employer or of their own accord in retaliation for that response. A question that also comes up as well is, what if a formal complaint is not made? And when we think about a formal complaint, maybe the employee did not follow the exact letter of the procedure for reporting, or maybe they didn't provide full information in their report. Maybe it was an anonymous report. As long as the employer knows or reasonably should know that something is going on in the workplace, their duties to act are still triggered. So if an employer knows or should know that something is going on based on circumstances, maybe observations, maybe anonymous complaints, they still have an obligation to act and to investigate and to stop that harm if there is harm happening. So employers are not allowed to ignore the problem or not respond because they were not formally told or because they did not have 100% of that procedure followed. They still have an obligation to act. And we will talk about that in some cases coming up in just a few moments. And speaking of that, now is time for our case example. So I will turn it back over to Carlyn.
Thank you. Okay, so just to go through some cases very briefly. So there's Emsley, I hope I'm pronouncing that right. So in this case, basically, it was a business owner that made repeated offensive comments and jokes towards an employee of a sexual nature. At the time, the employee didn't report the jokes because she was dependent on her job and was worried about losing her job. The behavior didn't stop. It escalated to the point where the employer tried to kiss her. He showed up at her home. And what's also interesting about this case too is that in some cases he asked permission to ask to physically engage in terms of, giving her massages and whatnot. And at the time she gave consent, but then later did make the complaint to the Human Rights Commission, and it was found that an employee doesn't have to make the report contemporaneously with the behavior, especially if there is an abuse of power in this case, such as this case where, she did consent to certain touching, she didn't make the complaint right away, but the tribunal found that a reasonable person would understand that, she feared reprisal and That's the reason for the delay. So you don't always have to object to the harassment at the time that it occurs. So the test is really whether a reasonable person would realize that these are unwelcome actions and have a fear of reprisal. Okay. Garland and Tackberry. So this is where we get into the duties of an employer in terms of providing a safe workplace, not just against employers and other employees, but in this case, a customer repeatedly made sexual comments about an employee. The employee made the owner aware, and the owner did speak to the customer. However, the customer continued to attend the place of business and continued to make, sexual comments, including a frightening and offensive comment. And when the harassment did not stop, the owner was found liable because he was allowing this customer access to the business and he was continuing to sexually harass the employee. So an employer, the takeaway from this is that an employer is not allowed to have harassment happen in the workplace, even if it doesn't come from another employee or the owner themselves. So something to think of when it comes to client or customer behavior. Okay. Motu and McLeod, this is a British Columbia case in which a nightclub server was required to wear a bikini top for a work event. In terms of uniform requirements, it kind of can go either way, and the real test is whether or not it differentiates between employees based on a ground of discrimination. So in this case, it was only the female servers that were required to wear revealing clothing and not the males. And so if it's a differentiated ground of discrimination, and that's the basis for the uniform requirement, then that could potentially be considered sexual harassment. And in this case, there was reprisal as well, that she was assigned to a different position and her work hours were reduced when she complained about her uniform. Basically, if there's a more difficult requirement or a way that they're expected to dress, if it's sexualized based upon a ground of discrimination, in this case, gender, then yes, that could be considered sexual harassment and may be against the law. TM and Manitoba Justice, this is actually, I think to date, the most punitive award and most significant award that was granted by the Human Rights Commission. A correctional officer was based on was subjected to harassment at work for a number of years. It was sexual harassment. It was also based upon sexual orientation, so there's some intersectionality here. The workplace did conduct a brief investigation. In this case, the person felt compelled to actually participate in some of the jokes at their own expense. The workplace actually closed the file and didn't let him know for a long period of time. So, these things kept happening. It kept re-traumatizing him. He eventually ended up on a medical leave. And next slide, please. Ultimately, this proves the intersectionality of some harassment. It can be on the basis of multiple protected characteristics. Having to participate in jokes against you for fear of reprisal doesn't necessarily negate sexual harassment. And this also is a pretty landmark case in terms of the duties of employers to fully investigate harassment. In this case, the workplace is aware, but the employee was a little bit afraid of reprisal and was preferring to deal with things anonymously, but the tribunal found that there were other things that the employer could have done, such as, when they became aware of the problem, they could have posted signs, they could have brought in some training, they could have done a number of things. They could have asked other employees, they could have fully investigated that the obligation didn't fall necessarily to the employee to have to fully launch or disclose identities in order for an investigation to be done. The employer could have been more proactive in this case. Okay, next. Okay, so going into practical tips of what you can do if there is any sort of harassment. So On a practical level, if an employee is experiencing sexual harassment, they should make it known. It's important to keep a record if there's some documentation of specific incidents, who's doing it, that's important to do. Seek out support, especially if there is somebody who's trusted in the workplace, and also report the incidents. Generally, our advice is to go through sort of the chain of command. So to go through a direct supervisor, document all the incidents of sexual harassment. If your supervisor isn't responsive, go to, say, a superior manager, go up the chain of command in the company. Next slide. Also, if there's a union, report to the union as well, HR. Every employee also has the option of reporting to, say, the Human Rights Commission, Workplace Safety and Health. Under the Canada Labour Code, complaints can also be made to the Manitoba Regional Office of the Labour Program. And so we have some information there of some of the online resources and where you can get that information. As I'd mentioned, under the Canadian Human Rights Act, so if you're working for a federally regulated employer, you can report to the Canadian Human Rights Commission, but your complaint should be made within 1 year of the last incident of harassment. Okay, next. The Employment Standards Code, the limit here is 6 months. So you can also report to them, who will investigate, employment standards. Really, they're a little bit more helpful when it comes to recouping lost wages or unpaid wages, especially if there's some constructive dismissal or wrongful termination. Okay, next. Workplace safety and health. Again, there's kind of a 6-month time limit here. You can report if there's any kind of reprisal, and also bullying or harassment can be considered part of an unsafe workplace. So they have the powers to actually investigate allegations of harassment, and they can look into possible compensation for that. And where most of these complaints go, and probably the most effective place to report, is to the Manitoba Human Rights Commission. So reports have to be made within 1 year of the last incident of discrimination or harassment. And the Manitoba Human Rights Commission has the power to investigate complaints. They also have the power to adjudicate. And as part of any kind of a compensation, they can compensate for lost wages, reduced wages. As part of reprisal, they can enforce policy changes and force workplaces to actually come up with a workplace sexual harassment policy if they haven't already. And they can compensate for things like damage to personal injury and compensatory awards to people that have had a successful complaint. Okay, next. Settlement agreements. This can also happen through the Human Rights Commission. You might be asked to do a settlement agreement. You are entitled to get independent legal advice. Sometimes there will be a non-disclosure. You might want to seek out a lawyer before signing anything that prevents you from pursuing litigation civilly. I mean, for example, if there was any sort of an assault component to a sexual harassment complaint, you might be liable to sue the person civilly, for example, for compensation in a sexual assault. So it's important to maybe discuss with a lawyer in a settlement agreement. Okay, in terms of criminal behavior, so assault, which means any kind of unwanted touching, which is the same for sexual assault, making threats are all criminal behavior, and they're offenses under the Criminal Code of Canada. So if you have been threatened, touched without your consent, either sexually or non-sexually, you can make a police report. Police will generally make a decision whether or not charges should be laid in that situation. If they are, you can go through victim services. There may or may not be a court case. There's also a compensation for victims of crime fund that you can apply to through victim services as well for compensation. Okay, next.
Okay, so I can wrap it up here. And we just wanted to let you know at the end of our presentation about some resources that our organization has as well, relating to workplace sexual harassment as well as to general legal resources. So we do have a workplace sexual harassment hotline, and that is where you can talk to Carlyn and you can speak to her directly. So that hotline is available generally Monday to Friday, 9 until noon. And so that can be accessed through a toll-free number or through we have a Winnipeg number as well. I just put the toll-free number here, but you can also contact Carlyn by email as well. And she will get back to you. So through this line, you can get legal information and advice, agency referrals, lawyer referrals. You can get advice on whether or not you should move it up the chain of command, whether you should make a formal report. You can get some support in these areas. All of our hotlines are free and confidential, so there's no charge to access them. And as well, we would never tell anybody that you called. You can contact with an interpreter or a support person if that is more supportive or comfortable for your situation. You can also just contact for information as well. It's available to anybody in Manitoba who has questions about workplace sexual harassment, who has experienced workplace sexual harassment. To my understanding, people also contact the hotline if they have been accused or questioned relating to workplace sexual harassment. And maybe before I move on, I'll just let Carlyn add anything if she has anything to add about the hotline.
Yeah, the hotline actually, we don't turn it off at 12. So basically anytime during business hours, you can contact us. I'll try to, if not give legal advice, then connect you to the proper resources. If a lawyer referral is appropriate, then we do that, in which case you are entitled to a free consultation with one of our panel lawyers if it's appropriate. There's no limit to the number of times that you can contact the hotline. There's always someone here to answer you or call you right back if we're busy.
Awesome. And related to that, we also have a regular law phone-in line, and that's for any other legal topic or question. So again, it's available during business hours, Monday to Friday, by email or by phone. Of course, you can email it at any time and you'll get a response during business hours. And so that is for any other legal topics. So if you have questions about employment law generally, or about anything, about family law, about estates, about criminal law, really anything, you can contact the law phone-in line. And so again, you can get legal information, some limited legal advice. You can get referrals to agencies, referrals to a lawyer for a free consultation. And this hotline is free and confidential, again, for anybody in Manitoba. And again, you can contact it as many times as you'd like. Even outside of the pandemic, we don't see anybody in person at our organization and at our offices. So the phone-in line by email or by phone really is the best way to access our services. And we also have a website, so it's communitylegal.mb.ca. Our website has resources for all sorts of legal topics, again, for things like employment law, family law, criminal law, estates, youth criminal law, all sorts of information. We have videos, we have printable publications, we have teaching resources. And we're also on social media, and the links are also on our website. So we have Facebook, we have Twitter, YouTube, LinkedIn. So please feel free to connect with us there as well. We do have, I mentioned our Community Legal Intermediary series. It's a series of webinars for people in the community who are often called upon to answer legal questions in the course of their work, but it's also available to anybody in Manitoba. So we do have that series, another round of that coming up this month as well. So if you're interested in that, we have more information on our website. We also have our annual law conference coming up, which will be delivered by Zoom again for free. So more information will be on our website and our social media. So please feel free to connect with us if you would like to get more information about those things. So thank you so much for sticking with us today and for inviting us to speak with you. We can now go into maybe the Q&A period, and I think I might close my screen just so that we're able to see the questions a little bit more fully. So I'll just stop sharing my screen now.
I see we have about 4 questions. So, is it okay if I kind of take the lead on the first one?
Yeah.
Okay,
definitely.
so there's a question. The first question is, when is sexual harassment in the workplace considered sexual assault, and how is sexual assault dealt with differently in terms of reporting? In terms of sexual assault, so harassment generally is more relegated to words and conduct, whereas assault is unwanted physical contact. Both can be reported through the workplace, through going up the chain, reporting to your direct supervisor, whatnot. In terms of assault, that's a little bit more of a criminal act. Like, there is the offense of criminal harassment, but that's a different standard. That's repeated unwanted communication, but there's a higher criminal standard for harassment generally than workplace harassment. So workplace sexual harassment is not quite the same as like a criminal harassment. It's a lower bar, as we mentioned. Even just one incident of sexual harassment, if it's from somebody in power, for example, that would be sufficient to prove sexual harassment. Whereas for the standard of criminal harassment, it has to be a little bit more severe, a little bit more serious. So sexual harassment would be reported through the workplace or to the Human Rights Commission, Workplace Safety and Health. As for sexual assault in the workplace, then you can report it to your employer. You can also report it to police, because that's when you're getting into the range of unwanted contact, unwanted touching, and that's where it becomes an actual criminal offense. So at that point, I would say there's not necessarily a duty to, or a suggestion to really go through your workplace avenues. That's where you can actually phone the police and report a crime. And there's also too, because I think this goes into one of the other questions about those who are maybe not comfortable with making a report or speaking out about harassment. There is a resource for assault specifically, which is Clinic's third-party reporting. So if you do have a little bit of discomfort, if you're not sure about reporting a sexual assault or it's mostly assault, whether or not you're going to be taken seriously. Clinic third-party reporting is a confidential service where they will report what you have reported to them to the RCMP, to the police, who will then review the case on a confidential basis. They won't take action without your permission. So in some cases, if they think that there's enough of a case that they want to pursue it, they will contact Clinic, who will get back in touch with you to determine whether or not you actually want to move forward, or if, say, it's something that falls into a pattern of other offenses that have been reported to them that they want to pursue, then they'll contact you. So that's one option. But yeah, the standard for assault and harassment in and outside of the workplace is a little bit different.
Some workplaces also have anonymous reporting mechanisms where I'm thinking of, I believe, the University of Manitoba, if I remember correctly. Sometimes there are mechanisms set up for those anonymous complaints. And so the relief that's available may be different, where a name is not attached. It might not, the way that complaint is processed may be different. But some workplaces do have a mechanism set up for kind of that anonymous complaint as well. So just to, again, respond to that question that's a little bit further down the list, but that was just something that came to mind as well.
Yeah, and as we mentioned in some of the case law, that if the employer is aware that there's an issue, like, you don't have to name names, you can remain anonymous, but they do have a duty to investigate so long as they're aware that there is an issue of sexual harassment.
And also, if you didn't, I guess, referring back to the case law as well, if you weren't able to make a complaint directly up the chain because it was, your fear of reprisal or fear of losing your job, but you did make a complaint to an overseeing body such as Workplace Safety and Health or the Manitoba Human Rights Commission, then that would be potentially not necessarily a bar either to a finding of harassment as well. Should we move on to question number 2? So the question is whether there is the potential for consideration after the 1-year mark under the human rights code, or whether it's possible to appeal. So section 23 of the Human Rights Code does establish that the time limit for filing a complaint is 1 year. Subsection 2 does allow for an extension of filing, an application for an extension of filing. So that is at the discretion of the executive director of the Human Rights Commission. So someone potentially would need to, it may be available to apply for an extension, but that's not guaranteed given the time limit that's set out in the law. It also states in that section, I just have it pulled up here, that the executive director shall not extend the time if they are satisfied that the extension would cause undue prejudice to the respondent. So that would be the person or the organization or workplace against whom the complaint is being made. So that is something to factor in, that the law doesn't guarantee that extension. So if possible, it is best to kind of initiate that complaint within that 1 year. Sometimes the human rights process, and I'm sure Carlyn can speak more to this, can take some time to get rolling. But as long as that complaint is filed within that 1 year, then that process does start from that point.
Yeah, that's exactly right. So yeah, I recommend generally to try to get it within that year as close as possible. We've dealt on the hotline with complaints that date 40 plus years, and at that point there's not really a lot that you can do. Yeah, so I don't really have much to add.
Looking at the questions again, I think we have answered now number 3 about advice for those who are fearful or not comfortable making a report, as well for printable access of or version of the slides. Certainly, we can send a PDF version. Once a non-disclosure agreement has been signed, can they be reopened at a later date when new information is learned? Maybe I can let Carlyn address that first, and maybe we can share it.
That depends. In terms of any kind of contract law, I think the presumption would be that it couldn't be reopened generally. However, there are certain defenses, without getting too far down the rabbit hole, there's certain defenses of duress, undue pressure or whatnot. Generally, if there's a non-disclosure, it's probably best to get independent legal advice, because any sort of contract, if there is independent legal advice, then that makes it more binding. But yeah, generally our recommendation would be not to sign any sort of non-disclosure without speaking to a lawyer first, because it's better to get that advice on the front end, because it's really no guarantee that you can set aside a contract or an agreement after it's already been executed. You'd have to really, really prove that you were coerced into it, or you really didn't know what you were signing, and that the remedy of setting it aside is appropriate.
Yeah, I think that is kind of the trouble with NDAs. I think even in kind of pop culture and Me Too and things like that, we see kind of the trouble with NDAs and of setting them aside and things. So potentially too, if you were to get legal advice, if you were to have a lawyer assist you, they might be able to negotiate terms of an NDA as well before you were to sign that, so that it isn't maybe as like every NDA is going to be different and worded differently as well. So that'll really depend on what the party who is proposing the NDA is wanting for wording in terms of what's going to be in that initial proposal. So it may be in your interest as well to try to have an NDA negotiated that maybe is less restrictive, but that's, yeah, exactly as Carlyn was saying, that's a real reason to seek out some of those resources as well for legal advice and some information about what rights you may be giving up, because it may not be clear from the wording of the non-disclosure agreement or the settlement agreement on what rights you may be forfeiting, but it may come down to some consequences later. So you're entitled to know what those rights are before you sign anything or consider signing. I also see a question here about how soon to expect a call back from CLEA's phone line. Maybe that's best for Carlyn.
It depends. It depends on the volume. There's some days that it's lower volume. I mean, if you call the hotline, and we appreciate that any calls to the hotline are related to sexual harassment or sexual violence only. We seem to be getting a lot of questions about wills to our hotline, which isn't quite appropriate. But in terms of our general line, it really is volume dependent. We try to stay open from 9 to 1, but on busy weeks, if we're just at capacity, then we'll turn it off earlier. I try personally to have it as a personal rule to get back to people within 2 business days, but this week has been insane. So, you know, we're getting closer to a little bit longer than that. Yeah, so it's really, really dependent. We do get back to everyone. It just might take a little bit more time. Okay. And sorry.
Oh, no, go for it.
I was going to say that there's a question about information resources directed to youth. In terms of workplace harassment or discrimination, youth have the same rights as any other employee or worker and the same responsibilities not to engage in harassment.
Youth also have, there are the provisions of the Employment Standards Code relating to youth in terms of working hours and things like that as well. And we mentioned it briefly in our presentation, but often situations where there is harassment or discrimination in the workplace, there can often be other workplace issues as well in terms of maybe non-payment or late payment of wages or facing non-payment of overtime or things like that as well. So youth do have, depending on their age, particular protections as well under the Employment Standards Code. So if that is something that's going along with the harassment, that might also be a resource for the Office of Employment Standards. But certainly, yes, youth have the same rights and obligations. And they would also be entitled to access services like the hotline and things like that as well, or to file a complaint if they chose to do that. Okay.
I think, this is all the question we cover. Thank you so much, Victoria and Carlyn, right? So I just put those information on the chat is about, I would like to share screen about the project. We are working through the partnership with the CERC and the clinic. So we have the virtual workshop. You could book it through our health educator. The email, you could find it on here. Then I already put the link for that website page. And also our upcoming opportunity training is the Creating a Culture of Consent in the Workplace, the half-day Zoom webinar from 1 to 5 on February 22nd. Please email us. I already put that email on the chat link too. So, and also that page you could connect it to notify the registration open. So this is a great opportunity for us to learn more about, how the culture of the consent in the workplaces. So on behalf of the Occupational Health Center, thank you so much again, Carlyn and Victoria to give us such a great information, talk about what's the legal resources, your program. I think this is such a great program to help the communities, to access all the hotlines. So you mentioned about the language interpreter. Do you know how many roughly of the languages available?
So we don't have an interpreter service ourselves, but just if someone felt more comfortable accessing with an interpreter, I'm sure that would be something that we could certainly accommodate, and we would welcome that so that people feel more comfortable. But unfortunately, we don't have the resources for interpreters ourselves.
Our staff lawyers, we do have about 2 staff lawyers that are fluent in French, but that's kind of the only language that we offer.
Awesome. Thank you. Once again, thank you so much. And thank you all of you to participate this morning session with us. So the session has been recorded. I will share with you guys later on when this is available, and also have the feedback evaluation. Hope you could participate to give us some more feedback, and we can move forward for the next coming event. So hope you all, have a great day and then great week, and stay safe all the time. Take care, everyone. Bye-bye.